The third strand of CLOC involves legal research and policy debates on community legal issues. One example of this is the note-taking project we undertook with the local Citizens Advice Bureau, looking at the impact of recent legal aid cuts on those seeking benefits.
My name's Simon Harris. I'm Chief Executive of Staffordshire North and Stoke-on-Trent Citizens Advice Bureau. Since April last year, when they introduced the cuts to legal aid, we've seen a number of changes, most of which are linked to the three losses that we knew were going to happen, one of which was the significant loss of service to clients, and about 1,100 people who had got specialist legal advice across a range of social welfare law contracts were not going to get that advice from April. On top of that, there was a significant loss of funding to the organisation, which we've had to work hard to try and replace. And the third loss was the potential loss of expertise. But because no funder has decided that they actually now want to fund specialist legal advice, and in particular representation at tribunal, we've had to rely on other types of project funding to try and patch together services and reconfigure a lot of our advice services to try and fill the gap in some way.
The activity that we've been involved with the CLOC project on has been within our welfare benefits team. For a long time now, in fact more than 30 years, this bureau has provided representation to people who need to appeal benefit decisions from Stoke-on-Trent and North Staffordshire. Now we're not in a position any longer to go with people to their appeal tribunals and represent them and put their legal case. We've been looking at lots of other ways we can help them, and that's where it's been great, because we've been able to develop this new activity using the law students from Keele to become note takers.
On that project, we accompany people to their work capability assessment to ensure that a good record is taken of the assessment. People who have been accompanied have by and large found that the healthcare professionals employed by Atos have carried the medicals out much more effectively, have been much more thorough, and even though they don't like having someone observing, they have had to accept them, and as a result they've delivered a better service. As a consequence of that, more people in that group than we would have expected have actually had their benefit confirmed and haven't had the medical go against them.
Part of the CLOC allows us to work with different partners. For example, the Staffordshire North Stoke-on-Trent Citizens Advice Bureau. I've been working quite close with their benefit team, which has enabled me to take part in a note-taking project, which would have me going into ESA assessments and making notes, supporting the client throughout, which I feel has been very valuable. The most recent case I did, the client suffered mental disabilities, and I feel that I was really able to help him and relax him in the situation. I was invited by the Citizens Advice Bureau to contribute to their recent policy, which has been launched in a newspaper, and I was asked to write an online blog in reflecting upon the actual experience of the client with the official ATOS policy. In addition to this project with the CAB, on the 20th of March, we contributed to the Legal Services Consumer Panel fact-finding visit on the Mackenzie Friend. This visit shared professional concerns about unregulated and potentially exploitive fee-charging Mackenzie Friends, filling the gap in the market left by the legal aid cut.
My name's Nick Hanning. I was a member of the Civil Justice Council Litigants in Person Working Party. Our remit was to look at the issue of access to justice for litigants in person, particularly because we recognised that with the cuts in legal aid there was going to be a huge influx of even more litigants in person than at present, and that's going to cause an awful lot of pressure on the court system, on court cases in the judiciary, and so it was important to take a look at what could be done to help those litigants in person and deal with cases more effectively, particularly from their perspective. That makes today exceptionally important from our perspective in seeing how Keele University has implemented a system of immensely effective collaboration with the local community and the court service to help litigants, and that's something that we're very keen to look at and take back as part of the evidence of how things can be done very much better.
The counter-argument to regulation is that the only reason that people can go to a Mackenzie Friend is because they can afford their services. And if you start to regulate something, you increase the cost to the Mackenzie Friend of providing that service, and their prices go up. So therefore, do you, through either the cost and inconvenience, drive Mackenzie Friends out of the market, or price consumers away from their services? And what's the sort of the balancing that has to be drawn?
I think one of the things that would concern me is if you don't have regulation, and I'm sure there are some excellent Mackenzie Friends who charge very reasonably, do a fantastic service, and would do nothing different if they were regulated. But I'm sure also, particularly with the opportunity, the gap that's just arrived in the market, and people who've looked at what's happening with legal aid and seen a way of making money, that there are people, for instance, who aren't even properly insured for doing this work. And so the amount that people could lose by things going wrong would actually be, I think, in some way, the risk that could happen could outweigh any benefits of it being terribly cheap. Because the problem is, although there must be some tremendously good ones who probably are very cheap, the risk is there are others who are really absolutely dreadful and who aren't necessarily cheap, or who are but are still dreadful. So I think it's a different set of weighing scales that I would be talking about than that.
I think it comes back to the basic question about what is a Mackenzie Friend. My kind of old-fashioned, rather naive attitude was a Mackenzie Friend was someone who did it voluntarily, who was someone who had a bit more knowledge, maybe a bit more experience, who would go along with you and sit there with you in the court, wouldn't speak, wouldn't represent you, but could kind of push you notes across the table if the judge didn't mind, and could sort of kind of stiffen your resolve during recesses and so on if you wanted to kind of hightail it out the building. Actually, what we're talking about here, if we're talking about people who are charging, is people who are offering a professional service. They're just offering a cheaper professional service. So I think
that's less regulated.
Yeah, cheaper and less regulated. If they're doing it voluntarily, then there's no need for any regulation. But it has to be absolutely clear that that's what the deal is. That the person is not offering any sort of, you're doing it almost like kind of one citizen to another. It's a kind of peer support system.
Mackenzie Friends, of course, have been with us for very many years, and initially they were genuinely the friends or companions of the litigant, and they'd just gone along to provide some moral support. And as the availability of legal aid has decreased over time, we've seen a growth in the number of individuals and organisations providing this type of service, and the courts have given very clear guidance as to what they expect. These people are supposed to be providing moral support, helping people with their papers, helping them in deciding on cross-examination questions and things of that nature. My experience of some other Mackenzie Friends, particularly some of the fee-paying Mackenzie Friends, is that they simply don't do that. And I've certainly had a case very recently where I saw a client who had been helped by a Mackenzie Friend, to whom she'd paid a significant amount of cash whilst on benefits, but who would actually have qualified for legal aid for that particular case. Where CLOC is different is that for the first time that I'm aware, we've attempted to set up a group of individuals who have some training in the court process. They've been familiarised with the courtroom, they've met some of the judges, they've seen how things work, they've had training from practitioners, they have an understanding of how to fill in the forms, what the protocol is, that sort of thing, which enables them to be far more effective as a companion, as a Mackenzie Friend if you like, but as a companion to the litigant in the courtroom, rather than somebody who has simply gone along to provide moral support.
The changes to legal aid have had a massive negative effect to and on victim survivors of domestic violence. It's very difficult for many women to meet the prescribed criteria to be granted legal aid, because you have to have the physical evidence. You're having to pay for medical reports. Women that have left everything behind, left their family and friends behind and had to re-establish themselves with their children, are starting from scratch, even trying to get enough money sorted for your bus fares, your phone top-ups. It's just really difficult. So any additional cost it's just denying access for those victims. So you're being re-victimised, basically.
Of course, the government's done a very good job of persuading the public that legal aid no longer exists for most cases, and that simply isn't true. There are many cases that do still qualify for legal aid, and the challenge that we have is how do we bring that to the attention of the litigant, to the public at large. And a very large part of the training that we deliver to the CLOC students is to make sure that they understand that legal aid is available, that they've got an idea as to the scope, they've got an idea as to financial eligibility criteria, and hopefully that they're then able to identify those clients who would still qualify for legal aid.
The Community Legal Companion Service has been cited in the Legal Service Consumer Panel report as an example of good practice.
The CLOC project facilitated our voices being heard and being involved in the parliamentary debate about the changes to legal aid in 2013, which is something that we would never have envisaged at all.
I think that the CLOC partnership is enormously important. I like to visualise it as a face of the clock. You've got 3 hands on the clock. You've got the big hand, the little hand, and the tiny hand. Now, if you imagine that the big hand is the judge and the court system, and then the little hand are the CLOC team, and the tiny hand are the parents that are running frantically here and there, not knowing where to go. Now, the little hand of the CLOC team, actually gathers up the parents and nurtures them and makes the big hand, the court system and the judges, seem and appear less scary. Not by doing the work for them, but empowering them to do the work for themselves, guiding them, not telling them or dictating them to them, but guiding them so that they know that they have the confidence enough to approach the judge and to state their case.
I think it's been a real game changer. The students have benefited massively from listening to true stories from real people, real experiences. They are going to benefit and become better and more committed and dedicated lawyers, barristers, judges, solicitors, people within the justice system themselves in the future, which is what we need.
So that was an overview of the CLOC project.
The project will be moving forward in our 3 key areas.
We look forward to collaborating with other law schools.
To roll out community legal education so other students can become agents for change.
To deliver the Community Legal Companion Service to assist litigants in person in regional courts.
And to develop a national research hub to collate and share data on access to justice.